Happy summer. I'm here with Tom Gerspach, who is the author of this newly published book, The Adventures of Tom Lawyer, Tales from the Courtroom. And so we're just going to talk with Tom about his journey as a medical malpractice defense attorney, and then his process of writing the book. So Tom, thank you so much for coming on today.
Nava, thank you for having me.
Absolutely. You're welcome anytime. Can you tell me about your education leading up to becoming a lawyer?
Yes, so I'm a native New Yorker. I went to high school in Western Long Island, just past the Queens, New York City border, public high school, and then I attended the University of Notre Dame in northern Indiana. Graduated in 1983, and then attended St. John's University School of Law in Queens, New York, and graduated there in 1987. And it was during those years that I worked for a firm that specialized in the defense of medical malpractice cases, Martin, Clearwater, and Bell. And that's how I got into the business, so to speak.
Yeah, and I noticed that undergrad at Notre Dame, it looks like you studied government. Is that right?
I did. Some schools, I guess, call it political science. So it was
Okay.
a liberal arts education focused on government.
At the time, were you thinking about law school? Because I know a lot of people who decide to go to law school want to study political science first.
So I was. That seemed to be where I was heading always. I'd been interested in law since I was a child, honestly, and so I didn't know what field I wanted to wind up in. I was thinking international law, and then I wound up becoming a trial attorney, and part of that was because I liked being in the courtroom. When I was watching other lawyers at work.
So I know a lot of attorneys, and many of them are not trial attorneys because they'll just say, I can't take the heat, or I'm an introvert, or one of my friends who's an attorney likes to say that her job is to write strongly worded letters, and that's about as far as it goes. But, as you see in the book, being a trial attorney, you're kind of like, a gladiator in there, and there's clearly some showmanship. So what would you say it is about you and your personality that makes you comfortable as a trial attorney?
So, yes, it's funny you use the word gladiator. One of my clients, the general counsel of a major hospital system actually used that word to describe us, as I sat in her presence. You have to have a little bit of the showman in you. Public speaking, I suppose, has to come a bit naturally. You can't be afraid of doing that, but I'll admit, it scared me from the beginning. And I remember questioning if this was something I could do. And even during one of the very first trials I had, it wasn't a medical malpractice trial, but it was a personal injury case. And I remember discussing with these more experienced attorneys, my concern about that. And then at the end of the trial, they assured me, you can do this.
That's good that you had mentorship. What is it about, can you take us to that moment where you're standing in front of, a jury, judge, your client, the opposition? Like, what goes through a trial attorney's mind, and how do you overcome any sort of like stage fright or anxiety?
Sure. Well, number one is don't screw up. The name of my book, The Adventures of Tom Lawyer, it's kind of an homage or nod to Mark Twain's novel, The Adventures of Tom Sawyer. And there's a passage in that book where Tom, as a boy, he thought he was so well prepared, and he tried to give a talk in front of his fellow students and totally became unwound. He wasn't prepared. So there's a lot of preparation that goes into the litigation and the preparation of a case, for trial. So the only way to not be afraid is to make sure you're prepared. If you have stage fright, then it may not be the career for you. If you're naturally averse to public speaking, but that doesn't mean you're not going to be afraid if you're not prepared. So, to overcome that kind of stage fright, the only way to do that is to make sure you're prepared and your opponent isn't more prepared than you.
Right. So I noticed preparedness is definitely a big theme of the book. And for those who haven't read it, it's kind of like almost an educational guide. So there's tips for every section. And I notice you spend a lot of time discussing jury selection, which I think a lot of people outside law don't know much about. Why is jury selection so important when you're trying a case?
Jurors are the finders of fact, we say. The judges speak to the law, and what they say about the law goes, but it's the jury's ultimate decision that matters in the case. And so you have to be able to communicate with them. I will have met my client years before the case comes to trial and spent hours and hours, hundreds of hours, perhaps, with my client preparing for the case. But you don't meet the jury until that moment that you begin jury selection. So you have to empower them, let them know that they're the most important people, in the courtroom, or as important as anybody else. And you have to be able to communicate with them. So how are they going to ever hope to find in favor of my client? Well, I have to do a good job at being a communicator, don't I? And in a case that involves questions about whether a doctor committed malpractice or not, I've got to be able to communicate the medicine to them, and what the standard of care was, what the standards the doctors were held to at the time the treatment at issue occurred. So if you don't communicate, if you're not giving them the information to empower them to make a decision in favor of your client, then you're going to fail from the get-go. I like to say it's the most important part of the trial. You have to kind of establish a rapport with them. And by that, I don't mean, become buddy-buddy, but you say things in such a way that you hope they come to, have reason to trust you. So even if at the end of the day, maybe there are other opinions and facts to consider, sure. But they're going to give you a shot.
Right. And you mentioned that it can take years between the beginning of a lawsuit and when it actually goes to trial. So what is that like for, the doctors who are defending themselves? That must really weigh on them as they're waiting for a case to come to trial. Like what's the psychological impact on doctors?
Yeah, good question. Think about that. Someone has brought suit against them claiming that they've harmed them. Rather than help them, they've harmed them, and that it was negligence to do so. If you're alleged to have caused a patient's death, it's probably the most serious claim that could be brought against a physician. Now they have that hanging over their head, so to speak, for the years it takes before the case is ready for trial. And in a very busy court system like New York, it can be several years from the time a suit is brought, the complaint is filed, until a jury is impaneled. And so all that time, they've got to carry on their business.
Right.
They've got to continue to see patients. But, it's something that helps them learn maybe how to be better doctors. So
Yeah.
even if they haven't committed malpractice, it educates them about how they could do something better and maybe avoid a lawsuit in the future. And all during that time, those years, they have to make time for me
Right.
because we're a team. And so I make sure that they're kept apprised at every step of the way, what's going on in the suit. And from time to time, when there's reason to do so, we meet and we talk about, where we are and
Yeah.
how we're going to prepare for the next step, which might be their deposition, or meeting with expert witnesses and the trial itself.
So, what kinds of support, you've touched on it a little just now, just meeting with them regularly, probably preparing them. But what kinds of support do you try and provide your clients as the trial goes on?
Yeah, it's not just advice about, the legal process, which is totally foreign to them. They're doctors, not lawyers, but it's a fair amount of hand-holding too, right? And you have to be a bit of a psychologist, but you have to just be a human being to understand what they're going through so you can help them and help them help you.
And you just mentioned something really interesting that, your clients are doctors, not lawyers. But interestingly for you, your job really sits at that intersection between medicine and law. So I guess I have two questions. How do you keep up to date with all the medical research coming out? And two, was medicine an interest of yours, or was this sort of more just how things fell out that you wound up in medicine malpractice suits?
It's a compound question, I would say. Objection. No, I will answer the second question first. Um, I suppose I was always interested in science. Not particularly, adept at it. I was never going to be a scientist. I was interested in biology. Um, and I can just say that I can't imagine another profession where you're paid to learn, about how the human body works. And it's just been fascinating to me. How do I learn? I've got clients. First of all, that's my primary resource to learn about, the medicine involved. Why did you do it this way? Or what were you thinking at the time, and why? And I've got medical literature to research, and I've got, we'll talk about probably experts to help me understand, and to help me understand if my client did things the right way or not. So it's fascinating. And, the human body, I suppose, we're changing, we're evolving, but not a great deal, right? Since I started practicing law, but medicine evolves, new
Right.
techniques are developed, and that's fascinating. Laparoscopic procedures weren't done when I started practicing law. Everything was through an open, wide, long incision. But along the way, there are these laparoscopic procedures through rather small incisions became the way to do things. But there was a learning curve,
Right.
and so there's a new standard of care developing. So I just found it fascinating. Of course, medicine is always developing new techniques, markers, diagnostic tools to assist in the diagnosis of diseases, and diseases are being identified. So it's just been very interesting.
And, speaking of doing research, this is a different type of research that you do when you try a case, but I didn't know this until I read the book that you're allowed to hire surveillance and you're allowed to use surveillance tools and shadow plaintiffs and things like that. Can you explain why surveillance might be used in a case and what it might do for you?
Yes, and there is a chapter on surveillance. Some of them are fun anecdotes, but I wanted to identify it as a tool, as you've correctly said. It levels the playing field is one way to look at it. A plaintiff may claim to have been harmed and to have an ongoing or even permanent injury, and we are entitled to and do receive medical records which may support that claim. I mean, that contention. But sometimes the records don't bear it out, or there's a question about whether the plaintiff is truly continues to suffer from an injury or not. And yes, the law permits us to surveil the other party, but we must turn over that information if asked for, and it always is. If we've obtained any surveillance tapes and they're requested, which they always are, we have to turn that tape over to again, even the playing field. It's called discovery or disclosure. But if the tape suggests that the patient, hasn't been harmed in the way he or she maintains, that can be very powerful at trial. Sometimes the plaintiff even modifies their contentions, or, maybe even drops the suit altogether once we exchange that information.
Is it common that a plaintiff would exaggerate their condition or what the doctor did to them or how well or poorly they're recuperating? Is that common?
I don't know, is lying common? I
Yeah, you
mean,
were giving
it
me a
goes,
face.
it, it goes on. That's all I guess I can say about it. It happens.
That's very
Uh,
chutzpahdik to bring a lawsuit if you're fully recovered and just fake it for years. That's very brazen.
well, yeah, it is. But then it's very helpful to the defense, and it's very good that we did the work to expose it.
And I know a lot of doctors have to pay really high insurance premiums as healthcare providers. Where does insurance intersect with what you do? Is that involved at all in covering a lawsuit?
Well, so the doctor will pay insurance premiums to be covered to a certain extent in the event a suit is brought or some investigation is being done of him or her. The insurance company will retain counsel for that doctor under the terms of the insurance policy. And that's where, I come in. Now, sometimes I already have a relationship with the doctor by having represented that physician or nurse or what have you in the past, and they will request me, like they might request any other lawyer that they've had a good experience with. But the insurance company that underwrites the policy will assign counsel. But the fact of the insurance policy is something that's not disclosed to the jury out of fear that it might influence them to think, well, the money is just coming from the insurance company, and we don't like insurance companies. So as long as it's not coming out of the doctor's own pocket, let's make an award, even if it's not just to do so. So there are reasons not to disclose the fact of insurance to the jury, and it's not done.
I was actually very surprised as someone who isn't in law myself. I didn't realize that if you have a defendant who's incarcerated, like someone you mentioned in your book, um, it's okay for the jury not to know that if it's not relevant. Like in your book, there was a defendant who was incarcerated for a separate, very serious crime, but then sued civilly, right, for malpractice. And so you had to buy him a suit and get him out of shackles and stuff to testify. Why? I'm just surprised. Like, if I were a jury member, I would think it's relevant that someone was in jail for a serious sexual crime or any crime, but being tried for something else.
So it's a very well developed area of law. And in New York, the information might come out if certain conditions are first met. In the case you're referencing in the book, which was a very interesting one for
Yeah.
me, it didn't come out because certain conditions weren't met. I'll just say in that case, the plaintiff made certain strategic decisions which did not permit him, and he knew that, to have that information disclosed to the jury. And it was right because as egregious as the doctor's behavior had been with the other patient, it had nothing to do with the case we were trying and the malpractice alleged in that suit. Nothing whatsoever. And you're always looking for fairness. Now, if I had done certain things during that trial, I might have opened the door for that information to come out, but I was careful not to.
So interesting because I spend a lot of my work life around, religious people or clergy people, and I think that perspective would be so different, like a more holistic approach to someone's character. But from the perspective of, secular law, it does, I guess, make sense to separate those two things from.
I agree. And look, I can also say that it's not that we didn't try to settle that case, as I recall. We just weren't able to reach what both sides considered a fair settlement. There was always the risk that information might come out. And that was one of the things that motivated us to try to settle the case, even though we felt strongly that in that case, the doctor had not committed malpractice. Now,
Right.
as you know, that plaintiff did recover, but from the other defendant in the case, not from my client. So it was justice all the way around.
After a set amount of time as a trial attorney for other firms, you founded your own firm. Can you tell us about taking that step in your career?
Yes, I'll use the frightening word again. I remember walking. So I had been working for a firm for 11 years, loved the people I worked with. It was just time to try something else. There comes a point, or there did come a point where I felt, along with my partners, that, we had achieved enough or, proven enough that this was something worth trying and we'd probably be successful. And so that's what we did. I can tell you I'm still friends with the senior partner that, we left, and we maintain a good relationship, a great relationship to this day. But I can also tell you that I remember walking down the street from 61 Broadway in Lower Manhattan to our new offices on Whitehall Street, 10 Whitehall Street, and thinking, okay, I don't have a single client. I've got a young family, 3 kids. What have I just done? But there comes a point, and there did, that, I felt very, very good and confident about it. And it was the right thing to do.
I know that feeling myself as a entrepreneur in a relatively new business. And literally the first 30 days after I filed and quit my job, I would wake up, realize I was conscious, and just start crying. And that was just how I began every day for the first month. How did you, I think this will be very inspiring to people. How did you overcome that fear?
I don't know that you ever do, but I was helped by the clients that I had developed relationships with. The first day you're hoping for the phone to ring, but you start getting the word out. As lawyers, we weren't allowed to because of, something called our fiduciary relationship with clients. I couldn't, solicit clients before we left the old firm.
Hmm.
But then you start putting the word out. And within that first week, I got my first trial. And then I
Wow.
knew, yes. And I remember just going off, clicking my heels to Brooklyn to try that first case, as a partner in my, new law firm.
So you mentioned that you had a young family at the time, and a lot of people who are thinking about starting a business, there's always a reason not to do it. How did you come to the conclusion that you were gonna take this risk and hope for the best?
I guess again, it's just a matter of confidence. For me, I'd taken a great number of verdicts already. So I felt confident that clients would come, and things would be all right. And that, I suppose I was making the right decision for them, for my small children, and my wife Eileen and our family.
So how did starting your own firm, how did it kind of change you internally?
And there's a whole lot of responsibility now. You're responsible for, the infrastructure, the overhead, the operations. Computers, were really just becoming a thing, believe it or not. As I recall, in 1999, there it certainly wasn't what we're dealing with now in terms of multiple factor authentication and hacking and all of that. But yes, you're taking on a great deal of responsibility too. And now you're not just a salary, you're not a salaried employee. Your interests are in keeping the overhead low, but I like to say, lean and mean, so you're as efficient as you could be, but not to the detriment of the client ever.
Definitely. And I also want to probe a little about, when it comes to changing you internally, because I want to connect this with writing a book, which is also a courageous thing to do. Do you think that starting your own business set you out on a different or better track in life than if you'd stayed working for somebody else?
Boy, I suppose so. Only because I can't divorce what came after from what might have been. I don't know how to calculate or process that. I know I became, one of the, in my original new firm, one of the two main lawyers, and then some years later, went out on my own yet again with another, young partner, and was trying, essentially all of the cases. So that provides opportunity for new experiences and new stories and a book, I suppose.
Definitely. Well, that brings me to the book because we have a lot of people on my subscriber list who are trying to do something creative, and that can take a lot of forms. You know how hard it is to write a book and make this idea real. How did you get the idea to write a book?
So it was something that had always been percolating. As I tried more and more cases and I collected, so to speak, stories in my head. I've got a great capacity to remember things. That's just, a gift, if you will. And from time to time, I would tell stories, and it might be at lunch with co-counsel, or it might be with a client to help educate them about what they were facing and what lies ahead. It might be to put them at ease. But the humorous ones always stuck with me. And so, eventually, it was 4 years ago, I sat down in the sand on a beach with a notebook and just started, writing an outline of the different anecdotes I had. And that's how it began. But then it developed into something, a little more than that.
And here's a question I love to ask people as someone who writes myself. Is writing hard? Is writing fun? How would you describe your relationship with writing?
I guess it's both. Um, I've been told I'm a good storyteller, and there's a device which I guess not too many use anymore called a dictaphone.
Mm.
Um, and so part of my training as an attorney and having to generate reports to the insurance companies, what was going on in a case, I would dictate everything on a little handheld device, and then it would be transcribed and I would edit that. So for me, dictating is the way that has always been most natural to me, just from my brain to my mouth into a machine. And so that's how I wrote, the large portion of the book. But it was fun too. So it was work because I wanted to get it right. And that's where the editing came in. So I would tell a story and then I would look at it after it had been transcribed and then I would edit it, knowing, oh, this could be better, or, this doesn't sound very interesting. It's just factual. I need to tell it in a way that's compelling. So that was work, but it was fun too. When I saw, oh, okay, this is the way the story was meant to be told.
Did you have to get permissions? Because a lot of judges and attorneys, and I think some clients are mentioned by name. Did you have to go and get permissions from anyone?
So for all of the parties, I use pseudonyms. I've changed the names. So not a single plaintiff or defendant is mentioned by their actual name. And there's a disclaimer somewhere at the beginning of the book, about, changing names. I use some of the judges' names, not all. Unfortunately, most of them are deceased now. That's how long I've been trying cases. But the few that I've left in there with their correct names, I had such respect for them and they're good stories. And I hope if they read it, they're flattering to them. So no, I did not feel I needed their permission to use their names.
And really, judges are, kind of public figures. So if they're going to be in the public eye, people are going to document their interactions with those people.
Yes, legally, I don't think that there's a problem with it, but I always think, well, what is this person going to think? Do I want to use their name or not? And so I was careful when I went through the book and used the pseudonyms I did for the parties and looking, at the judges' names that I used. I did change, a couple of names only because of the issues involved, maybe close calls, things like that. But I think you're right. I didn't need to change them,
Yeah.
and for the most part, I haven't.
What would you say are the qualities that make for a good judge?
Oh, well, it all begins with, the attorney before them too, right? So, we both have to accept responsibility for what happens in the courtroom. And I can tell you as a young upcoming trial attorney, I would sometimes tip my hand at, how upset I might be or that I disagreed with, a ruling. The judges, it's their courtroom. That's the way it is. To answer your question, they need to be good listeners, and so do the attorneys. And of course, so does everyone in the courtroom, including the jurors. So I always appreciated a judge who at least listened to my argument. Very early on, I got to understand that I just wanted to protect the record. So if I thought a decision was incorrect, I just needed to state my position and the reasons for it, and succinctly so, and not suggest that I was all unhappy, just so that in the event I did lose the trial and we wanted to appeal the case, that might be a ground for appeal, a judge's incorrect decision, if it was. So I appreciated when judges appreciated that about me. And sometimes it takes more than one trial, or you have to have that experience where judges talk to each other and they say, oh, Gerspach's before you. He knows what he's doing. So that there's that trust. He's not, Gerspach's not wasting my time. He's going to make his record. I'm going to let him do so. It's nothing personal. And then we move on. So good listeners, nothing personal. Um, and understanding the law. And one of the judges I mentioned in the book, did a great job, as many of them do. Researching the law. When there is a legitimate dispute that maybe is novel, it's not something that's occurred too many times or recently for that judge. They take the time to do their own research and look very carefully at the submissions by the attorneys. So those are all very good qualities, as well as just beginning the day with a good morning. When the judges understand how hard it is to try a case, it makes for a more enjoyable experience for the trial attorney.
Yeah, definitely. And um, we can switch back to your book momentarily, but just one other follow up question. What are the ethics of being an attorney who's representing someone who you come to realize probably did commit malpractice or was negligent or worse? How do you handle that ethically within yourself?
Well, within myself, everyone's entitled to a defense, right? At the beginning, you don't know whether there was malpractice or not. You may have a hunch, based on, what you receive from the plaintiff in the complaint, and then looking at your client's medical records and other medical records. And then you develop more than a hunch. You develop, an opinion about it after meeting with your client, which is either strengthened or maybe weakened after meeting with other doctors who practice in that same area of medicine. Where there's gray area, where even experts may disagree, and they do. If a case comes to trial, that means the plaintiff has an expert willing to say, because they're required to produce expert testimony, willing to say that my client committed malpractice. And then I have an expert or experts, giving a very different opinion. And that's why the jurors, as judges of the facts, have to make that sometimes very difficult decision after assessing all of that information, some of which is in conflict with each other. But where it's a clear case of malpractice now, and the case is approaching trial, yeah, I try very hard to have that discussion about settlement. And in most cases, then that's where we wind up. And even with the insurance companies, help and blessing, if you will. If you don't have a doctor willing to defend the case, it can be very challenging to defend the case at trial, right?
Right. Yeah.
I hope that answered your question.
Yeah.
So ethically, I feel like I'm doing the right thing. I'm trying to get to the answer. All along, I'm giving my client help, and then counsel, and the counseling ultimately may be to settle the case.
Right. So just going back to your book, thank you. Just going back to your book, can you tell me what's been the most challenging aspect of writing a book?
It might be what comes after you've written a book. So for me, it was an almost 4-year process, writing and editing the book. The stories were told. I realized early on it was more than just anecdotes. There was an opportunity to instruct. And so I organized the stories into different chapters, each chapter discussing a different phase of a trial. Jury selection, as you've mentioned, the first phase, and then opening statements, and then evidence, and so forth, all the way through to the verdict. I tried to tell the stories in a way that they were, attention grabbers, but they all were selected for a particular purpose. There was some area of law, some lesson to give. And when I say to give, the audiences I always perceived as being young lawyers and law students who might be interested in a career in trial law, and healthcare professionals. Because, although it's written from my perspective as a trial attorney, and as you read it, it sounds like it's directed to the attorneys, the clients often don't know, unless they've been through a lawsuit once before, they don't know what's ahead. They don't know what their role is in all of this. And so
Right.
the book, I think, is very helpful in providing that information to doctors, nurses, and other healthcare professionals too. And then there's the general population, because I think the way I've written the book is I wrote it as if I were addressing a jury. If I hope to win a case, the jury had to understand everything, even the medicine. And so I've written it in such a way that non-lawyers, non-healthcare professionals can learn from it, understand it, and I think be entertained by it. So then you get all that done, and then you realize, okay, now how do I get it out there? You know, and that's a whole other piece of work.
Yeah, I think a lot of creative people and first time authors don't realize that they're expected to be PR people and not just the creator of a certain work or artistic or literary piece. So, how's that aspect been for you?
Yeah, so naively, I guess, we think, oh, I'm writing a great book. This is going to be of interest to people. Um, but unless you have a big publishing house, behind you that's promoting the book, it's on you. And I learned along the line after the first, couple of years, well into the third year, that I was either probably going to have to independently publish the book or self-publish it, and that so that the marketing, as you say, was going to be on me. So what I did at first was, I spoke to some people who, I'd been put in touch with, very happily, who were very generous in sharing their experiences, about, how do you, get an agent? So that's the first thing I learned. Get an agent. You write something called a query letter, where you write certain information about your book, who you perceive the audience to be, and you're supposed to provide comparables, 5 titles, in the same genre or subject matter as your book. And so I spent a great deal of time doing that and honing it. Um, but then you speak to other people who started touting to me, the value of pursuing the independent, publishing route. So I was fortunate to be put in touch with, well, my son-in-law Chris's uncle, beloved uncle, is a journalism professor, sports journalism, at the University of Oregon. And he read a completed draft and gave me his thoughts, um, and support and encouragement. Put me in touch with somebody he'd worked with and knew about, John Hance, in New York. I spoke with him, and then thought, well, maybe he could help me. And he had a little, he's got his own, outfit there, an independent, publishing group, Tender Fires. He works with another guy, Kevin Horton. And anyway, so I met with John, found him to be wonderful. We connected. He's a New Yorker like I, have been, and sent him the book. He gave me his thoughts and, cleared out the underbrush, as he might say.
Mhm.
I knew it needed, editing. I thought I knew what needed to be edited, but I kept a lot of things in there that I thought, if we're going to trim it, this is what's going to come out. He, for the most part, confirmed that and went a little further in clearing out the underbrush.
So, yeah, I think a lot of people are working with indie publishers, as more of these big publishing houses consolidate. And, even if you have a large platform, a first time author, selling their book through one of the major publishing houses might have still a very small marketing budget. So, I think the independent publishers, they can give you, the attention and the resources that some of the bigger publishing houses wouldn't be able to anyway.
Yeah, I think that's true, and I understand, from speaking to John and others, that indie publishing is becoming more common, and eventually, maybe it'll be more readily recognized, and make
Yeah.
us first-time authors easier to market.
So what's the next step for you now that you've written this book? It definitely to me has a sort of educational bent to it. You're also retired now. Are you looking into teaching, a second book? What's next for you?
So I'm not so sure I'm retired. I'll just say that, one thing I miss about the courtroom is the people contact. So it's been 2 years now since I tried, almost 2 years, not quite, since I tried my last case. And now that I've completed the book, um, and I've had the opportunity, the benefit of time, I'm not so sure I've tried my last case. I'm interested in teaching, and maybe that'll give me what I need in terms of people contact. I've always been interested in teaching and mentoring. I've done a little bit of mentoring. I would probably, I think, love the opportunity to get in front of a classroom of aspiring trial lawyers.
For sure. Well, great. Well, I wish you all the best with that next step and more. And thank you so much for coming on and speaking with me.
Well, you're very welcome. I appreciate the opportunity. There may be a second book, I may wind up fictionalizing, the Tom Lawyer, character, and using some of these anecdotes, but so many others that weren't included in the book. The way I connected with people, jurors, I tried to be forthright, straight with them, and I injected humor, where I saw it was appropriate to do so, and so that's something I'm maybe fascinated by doing, in a second book, continuing it, but as a work of fiction.
Yeah. Do you have any closing advice to anyone who's writing a book right now?
Yeah, keep at it. That's the one thing. Learn from others. Life's a learning process. I'm still learning. And I learned so much in this process, things I didn't know that I was in for. I'm very happy to help anybody if somebody's interested and wants to drop a phone call to me or an email or visit my website and get in touch with me that way. Gerspachlaw.com. That's cool too.
Great. Well, thank you so much, Tom.
Thank you, Nava. Appreciate it.